It was good for 10 years, almost 10 years.
Okay.
But it's just a bump in the road, you know.
All right, make better choices. And if you need help, I'm here, okay?
Thank you so much.
All right.
Have a good day.
You too. Good luck to you.
Thank you. Can I have the excuse?
Yes. Yes.
If you're ready.
This case starts like many others, but don't let that fool you. Jeffrey Flores is standing in court facing a motion to revoke his community supervision, and every word spoken here carries serious consequences. Miss a drug test, fail to report, misunderstand the process, and suddenly freedom is no longer guaranteed. What makes this moment intense isn't just the charges. It's the confusion, the hesitation, and the realization slowly setting in. Because today, the court isn't here to debate excuses. It's here to decide whether probation continues or prison becomes reality.
Hello. Court is calling 2024 CR 012214 State versus Jeffrey Flores. Can I have parties announced for the record?
And Brittany Sparks for Mr. Flores.
And are you Mr. Flores?
Ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
I agree, because I was off with CP, right?
No. That's not my question. I want you to listen to my question.
No, sorry.
That's okay. This is a motion to revoke community supervision. It's complaining that you didn't complete certain things. Did you understand that?
I didn't go.
Your Honor, I might need to talk to him again.
Okay.
He is requesting more time from the court. I understand that he needs to plead not true to this judge. He would like to hire an attorney.
Okay. All right.
I don't need
She does.
Okay.
My question is, did you review this with your attorney? Did you understand it? Are you the same Jeffrey Flores who's placed on community supervision in 2024 CR 012214 for the offense of theft of property less than $2,500 with 2 or more previous convictions on February 20th, 2025 for a term of 4 years? Is that you?
Yeah.
State.
Answer your question.
Yes.
Thank you so much.
Violating condition number 2 on or about the 21st day of March 2025 in Bexar County, Texas, the defendant Jeffrey Flores did then and there fail to submit to drug testing as directed by the court officer, supervision officer, or duly authorized agent of the court in violation of condition number 2.
How do you plead to that?
I plead
True or not true?
True.
And then violated condition number 4
This
in
is
Bexar
where the
County.
stakes become very real. A motion to revoke community supervision isn't a warning. It's the court saying probation may be over. By pleading true to missing drug tests and failing to report, the defendant is essentially admitting violations that legally allow the judge to sentence him to up to 2 years in a state jail facility. Many defendants don't realize that once these pleas are entered, the court's discretion widens dramatically. At this point, the judge isn't required to show leniency, only to follow the law.
In Bexar County, Texas, the defendant Jeffrey Flores did then and there fail to report to the supervision officer as directed for the months of July, August, and September 2025 in violation of condition number 4.
How do you plead to that? True. Did you understand by pleading true to violations? Oh, I'm sorry, state, are you waiving 14AA?
State is waiving the remaining condition.
Any objection?
No, Judge.
Did you understand by pleading true to violations 2 and 4, the court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility? Knowing that, do you still wish to plead true to 2 and 4? Court will find 2 and 4 true. Is there a proposed agreement?
But I don't believe there is a proposed agreement, but state would be asking for revocation and sentencing for those 2 years.
All right. And defense, what are you requesting?
Your Honor, he has expressed to me, Judge, that he would like to hire some time to hire an attorney. We did receive 2 separate recommendations from the state. So in all honesty, Judge, we would just like for him to have more time to hire the attorney of his choice.
Now, here's the thing. The question is,
No.
no, go ahead.
I just really would, because I'm really confused, like, I'm really, because honestly,
This
on the
moment
drug test,
highlights something we see far too often in courtrooms. Confusion mixed with panic. The defendant begins explaining medical issues, drug tests, and hospital visits, but the problem isn't the explanation itself. It's timing. Courts operate on procedure, clarity, and documentation. When communication breaks down, even legitimate issues can lose credibility. Judges must pause situations like this not out of kindness, but to ensure due process is protected before irreversible decisions are made.
on the drug test point, I had to get hit by a car, and I had told them, and I brought them to my hospital, but I was.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, so this is what I'm going to do. I've already sworn you in. State your name for the record.
Jennifer.
All right, so this is what's going to happen. You've been sworn in. I'm not going to take testimony from you just yet because it appears that there may be miscommunication and you changed your mind about certain things. So, no. So here's what I'm going to do. I'm going to give you a chance to speak with your attorney. And then if you still want to proceed, then I'll take testimony from you, okay? So just speak with her for a moment and then you all can come back, okay?
Yeah.
All right, thank you. All right, anyone else ready? Yes. Page 4.
The next morning.
All right. Ready?
Yeah.
You all ready to proceed?
Yes, Your Honor.
All right, the court is calling 2024 CR 012214, State versus Jeffrey Flores. Could I have parties announced?
And Brittany Sparks for Mr. Flores.
Are you Jeffrey Flores? All right, the last time we were here, you said that you were going to have an attorney. Are you having an attorney or are you going to proceed with Ms. Sparks?
Ms. Sparks.
All right, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
I did, yes, sir.
Are you the same Jeffrey Flores who was placed on community supervision in 2024 CR
When the case
0122?
returns the next morning, the tone has shifted. The court gave time to consult counsel, but the underlying violations haven't changed. This is a critical point many viewers miss. Delays don't erase violations. They simply ensure the defendant fully understands what's happening. At this stage, the judge is confirming awareness, not negotiating facts. The question is no longer what happened, but what consequence FO.
12214 for the offense of theft of property less than $2,500 with 2 or more previous convictions on February 20, 2025 for a term of 4 years. Is that you? All right, state.
Violated condition number 2, on or about the 21st day of March 2025 in Bexar County, Texas, the defendant Jeffrey Flores did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Violated condition number 4, in Bexar County, Texas, the defendant Jeffrey Flores did then and there fail to report to the supervision officer as directed for the months of July, August, and September 2025 in violation of condition number 4.
How do you plead to that? True or not true?
State will waive the violated condition.
Any objections?
No, Your Honor.
Did you understand by pleading true to violations 2 and 4, the court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility? Knowing that, do you still wish to plead true to violations 2 and 4?
I do not.
Court will find violations 2 and 4 true. Is there a proposed agreement?
Yes, Judge, the proposed agreement is to grant state's motion and sentence to 18 months.
Is that the agreement?
It is, Judge.
Are you asking the court to follow that agreement? Are you waiving your right to appeal?
An 18-month state jail sentence may sound negotiated, but make no mistake, this is still incarceration. The court followed the plea agreement, imposed a substantial fine, restricted contact with the retail location involved, and reinforced felony consequences like firearm restrictions. This outcome reflects the court balancing accountability with structure, offering treatment recommendations while still enforcing punishment. It's a reminder that probation violations don't end with warnings. They end with sentences.
And the court will sentence you to 18 months in the state jail facility. There's to be no contact with Dollar General store. There's a $2,000 fine. Time and money will run concurrently. And the court will request the therapeutic community. Oh, State, you may be excused. Did you review the trial court certification with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing, Mr. Flores. If you don't make changes in your life, you're going to end up in prison. You know? If you have a drug problem, take care of it.
was good for 10 years, almost 10 years.
Finally, in the end, this case is a clear example of how probation is both an opportunity and a test. The court provided structure, time, and options, but responsibility ultimately rests with the defendant. Judge Boyd's closing message wasn't about anger. It was about reality. Without real change, the system will respond with harsher consequences. If you found this courtroom moment intense or eye-opening, make sure to like this video, share your thoughts in the comments, and subscribe for more powerful courtroom breakdowns you won't see anywhere else.